very good morning, namaste and adab to all the distinguished guests here. On behalf of the author, Mr. Dinesh Kumar Sharma, and the publisher, Mohan Law House, I, Fauzia Shakil, extend a warm welcome to all of you to today's book release. May I request the dignitaries to please come onto the dais. Thank you, sir. On the dais, we are honored to have with us Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India, Honorable Mr. Justice Ashutosh Kumar, Judge, Patna High Court, Professor Faizan Mustafa Saab, Vice Chancellor, Chanakya National Law University, Patna, Dr. Abhishek Manu Singhvi, Senior Advocate, has very kindly joined us virtually, and of course, the author of the book, Mr. Dinesh Kumar Sharma, former District and Sessions Judge. I also extend a warm welcome to the esteemed audience. We are privileged to have amongst us Mrs. Jayashree Vishwanathan, who is here with us today. Honorable judges of the Patna High Court, former judges of the High Court, judges of the District Judiciary, present and former, senior advocates and advocates of the High Court, Mr. Vinay Ahuja, proprietor, Mohan Law House, and ladies and gentlemen. We have gathered here to celebrate the release of the book titled Of Petals and Fragrance in the Flower of Justice, authored by Mr. Dinesh Kumar Sharma and published by Mohan Law House. The book is an anthology of articles penned by the author over a period of 4 decades. The earliest article on pollution and marine environment was written way back in 1978, while the author was still studying law, and when the concerns regarding the degradation of environment and development of environmental law were still at early stages. His last article on consumers and human rights was published in 2016, while he was serving as the president of the District Consumer Forum after his superannuation as District and Sessions Judge. The articles in the book, penned over decades, cover a wide variety of themes and are on diverse branches of law, with articles on criminal law, civil law, constitutional law, environmental law, and matrimonial law. The book will be of immense interest to law students, practicing lawyers, and judicial officers. To a law student and a lawyer, his articles offer an interesting insight into the functioning of the district judiciary. To a judicial officer, the articles provide an overview into the practical challenges faced by the courts and explores ways and means to address these challenges. The book carries a fitting foreword by Justice Vishwanathan and introduction by Dr. Singhvi and Professor Faizan Mustafa. Justice Madan Lokur, Justice Sandeep Kumar, and Justice Dharnidhar Jha have also given their valuable comments on the book. I will now take a moment to honor our esteemed guests on the dais. I request Mr. Vinay Ahuja of Mohan Law House to please present a bouquet and welcome Justice Vishwanathan. May I now request Siddharth Sharma to present a bouquet and welcome Justice Ashutosh Kumar. Dr. Vaishnavi Sharma will welcome Professor Faizan Mustafa. I've mentioned. I request Mr. S.P. Singh, Registrar, CNLU, to honor the author, Mr. Dinesh Kumar Sharma. I now call upon the director of today's event, the person who is instrumental in getting all the lead actors on the stage today, the author's devoted son, and my senior friend from NUJS, Mr. Siddharth Sharma, to please deliver the welcome address.
Thank you, Fauzia. Honorable Mr. Justice Vishwanathan, Honorable Mr. Justice Ashutosh Kumar, Dr. Singhvi, who joined us virtually. Thank you, sir. Professor Faizan Mustafa, Shri Dinesh Kumar Sharma, and all the esteemed dignitaries and guests who are present here today for this occasion. A very good morning to all of you. I am Siddharth Sharma. I am a lawyer by profession. At present, I am a corporate lawyer, but I stand here today as a student of law and as a proud son of my father, whose release of the book is the occasion which has brought all of us together here. It is my proud privilege and truly a pleasure to welcome our chief guest, Justice Vishwanathan, who not only wrote the foreword, but also very gladly accepted our request to be here today. As a senior advocate and one of the most versatile, skilled, persuasive, loved and credible faces of the Supreme Court bar, he was an inspiration off the bench, and now on it, he continues to be a role model as a compassionate, just, and a truly committed voice to the rule of law and in the apex judiciary. Thank you, sir. We also have Mrs. Vishwanathan. Jayashri ma'am, thank you for being here today, who is also an author in her own right. He's written a beautiful book for children. And so welcome, ma'am, to today's program, and to Patna, because it is your first visit. It is again an honor for me to welcome Justice Ashutosh Kumar, who very happily and readily accepted, despite his pressing other demands on his time. Justice Ashutosh Kumar, earlier in the Delhi High Court and now in Patna High Court, of course, is again a very popular, loved judges. So thank you, sir, for being here. We have seen you from a distance at the bar, and I'm so happy that you are here today. I'm delighted to extend my heartfelt welcome to Professor Faizan Mustafa, Vice Chancellor of Chanakya National Law University at Patna, who is not only a very learned academician, and before this he was the Vice Chancellor of Nalsar Law School, but he's also a person who speaks his mind and has this great ability to simplify the law and its various nuances and complexities, not only for his students, but also for common laymen, to understand them better and correctly. Thank you very much, sir. He has also very kindly written an introduction for the book. It is my privilege to respectfully welcome Dr. Abhishek Singhvi, the senior advocate and a fourth-term parliamentarian, who despite his extremely busy schedule has spared time to grace this occasion. He tried his best to be here in person, but couldn't come, but he's managed to be present virtually before this special bench, as it were. Dr. Singhvi is a giant of the bar and a go-to lawyer for virtually everyone, and for all those who can afford him. His intellectual caliber, brilliantly original mind, and great advocacy is well known, and he combines it with an exceptional ability to manage time and multitask to a degree which is incredible. We can see him appearing in Supreme Court, High Court, NCLAT, before the Election Commission, later in a press conference, then on a TV debate, and occasionally enjoying a music concert, all in a single day with same degree of ease and excellence. Thank you, sir, for being here. Dr. Singhvi has very kindly written a prolegomena for the book and represents a special connection to how this book was originally conceived and envisaged. I think he will speak about it. Lastly, it is a very proud and immensely happy moment for me to welcome Shri Dinesh Kumar Sharma, my father, who has authored this book. He is in a way today's Sutradhar, the reason why we are all here, and is also the foundational reason why I am here and what I am today professionally. As a son, whatever I would say would seem and sound biased, but let me say this. I have seen my father work very hard, and having almost an insatiable desire to read and write. He didn't let the limitations of a village life and early education, and later lack of adequate resources and infrastructure, and even recognition, come in his way of pursuing excellence and commitment to his chosen field, that is service to the district judiciary. I had from my early childhood the opportunity to see my father doing the painstaking job of attending to court works, writing judgments till late hours, sometimes under a kerosene lamp. Those were the days when Bihar did not have uninterrupted electricity supply. And also going beyond the routine and writing and contributing to law journals, articles on topics of law. Later on, as a student, when I took up the study of law, it was his inspiration, and that is how I attempted a career in law. Therefore, it is a very solemn occasion for me too. Thank you. I will end by respectfully welcoming all of you, the honorable sitting and former judges of Patna High Court, the judges of the district judiciary, the respected officers of the executive, the learned members of the bar, the publisher of the book, Sri Vinay Ahuja ji, members of the press, and all the dignitaries who are here today to grace this occasion by your august presence and make the event indelibly memorable for all of us. I would now request Fauzia to take the program forward. Thank you very much.
Thank you, Siddharth Bhai. Without much ado, please allow me to introduce the author and the man of the moment, Mr. Dinesh Kumar Sharma, who has put in years of his wisdom, knowledge, and experience into the book. After completing his master's in science, Mr. Sharma studied law at the prestigious Banaras Hindu University. He practiced law at Patna before joining the Bihar Judicial Services. In a career spanning over 3 decades, he served the district judiciary in different capacities and superannuated as district and sessions judge Vaishali. This book is an example of his legal scholarship and industry. I now request the author of the book to please say a few words on this joyous occasion.
Thank you, Fauzia. Honorable Mr. Justice K.V. Viswanathan Sahab, Honorable Mr. Justice Ashutosh Kumar Sahab, Professor Dr. Mustafa Sahab, Vice Chancellor CNLU, Honorable Judges of Patna High Court, Honorable Emeritus Judges of Patna High Court, honorable members of the bar, all the dignitaries present here, law students, journalists, and friends. At the outset, I must crave your kind indulgence for not having appropriate words at my command to express the sense of gratitude, the elation, the edification, both intellectual and spiritual, that are passing my heart and mind. All that I should say is that it is a momentous occasion, a historic occasion in my life, and all credit goes to not to any acumen of mine, to your generosity, your grace, your blessing. So far, the inspiration to get this book published is concerned, I respectfully recollect a very important event in my life when I had an occasion to meet the late lamented Dr. L.M. Singhvi Sahab, the great jurist, senior lawyer, literature, parliamentarian, diplomat, and whatnot, when I had gone to present to him a book of mine, earlier published, on Hindi poems, in which Dr. Singhvi had been kind enough to write a foreword. I had met him twice, once at his Wellington Square, something like that, residence at Delhi. And on that very day, or perhaps a day thereafter, he was to leave for England to attend in the centennial celebration of Shakespeare that was proposed to be held there. He took my manuscript there, he wrote a foreword from that, from England. So I have annexed that facsimile copy of that as a foreword in that book, which was published in 2003. Thereafter, when the book was published and released, I had gone there with my son Siddharth. He was the law student then, to present a copy of it. And there a talk erupted, and there were some law books in the library. I said, I have authored some articles. He saw it and said, when you write a couple of more articles, get an anthology published. And I remember he had mentioned two books. This Our Constitution, Defaced and Defiled, authored by Palkhiwala, and A Judge's Miscellany, authored by Justice Hidayatullah. He said, those books are of this type. Various essays written on law, compiled in a book. I strictly remember. So when one gets an opportunity to meet great men, these are the ideas that one is benefited with. I'm glad that today his illustrious son, Dr. Abhishek Manu Singhvi Sahab, is here to grace us by his kind presence virtually. I welcome him most heartily. As to why and how I wrote these articles, it is not very easy to narrate. There is a saying in philosophy, I think the idea had come from René Descartes, the Western philosopher, who said, I think, therefore I exist. So this thoughtfulness, the thinking, is the proof that I exist. And there is another thought prevalent in Indian philosophy, that I exist because I think. I exist therefore. So thinking is the linking thing in the very human existence. So as a judicial officer, it was a very modest beginning. The issues naturally as a routine is to come before me as a judge, as a judicial officer, where pleadings were there from one side, either in civil side or criminal side, in one form or the other. There were counter pleadings were there, then argument by one lawyer, the counter arguments by the other lawyer, and then the issues, and then the thought over them, and then the decisions. But apart from the issues arising in those legal proceedings, I found that law is a subject which raises many issues and not confined only to the decisions concerned. So those issues, they spurred me from within. There is a couplet in Manas, Mudiya aankh katahu ka sunahi. Close your eyes and there is nothing. But somehow or the other, those issues, they inspired me from within not to close my eyes. And they demanded me a care from me and addressed to them most humbly. So the methodology in writing an article is entirely different, characteristically different from that in writing a judgment. There we have a pleading from one side lawyer, the counter pleading, the argument, counter argument. But when you conceive an article, a theme for an article, you are to become the lawyer giving the pleading. You are to become the lawyer giving the counter pleading. You are to assume the role of an arguing lawyer. You are to assume the role of an adversary lawyer. And then, on the issues, you are supposed to pronounce your opinion as objectively as possible. It is not very easy to become, it is rather impossible to become absolutely objective. But the attempt is to become more and more objective and less subjective. That is what I adopted the approach. And I tried my best to make the writings convincing to the learned audience, ultimately the lawyers and judges or the law students who are supposed to read it. So I will give one or two examples. I must observe the brevity because time constants has been mentioned. There was the prevailing ethos in judiciary among my colleagues that constitutional law is an arena in which district judiciary is not supposed to treat. It is exclusive preserve of the High Court and superior judiciary. But I felt it otherwise. And not only I thought over it, but I applied some relevant provisions of constitutional law. And I found that they not only ornamentally enriched by orders and judgments, they substantially changed the outcome. I won't go in much detail. In the article, namely District Judiciary in Constitutional Law, I have tried to objectively identify some situations, circumstances, where the application of constitutional law principles are eminently relevant for district judiciary. And the result was so much characteristically different that what would have been a judgment of conviction turned out to be a judgment of acquittal. So it was not just academic and ornamental, it changed the very character of the judgment and quality of the judgment. Another example, I was placed at one station, then there had been what we call mega lok adalat organized as ordered by the Honorable National Legal Service Authority and all that. And simultaneously, on that very day, lawyers had called a strike because of there's some problems, some demand of theirs. So they had boycotted their participation in Lok Adalat also. So it just passed over, but that event raised the thought process in me. I thought that I should jurisprudentially probe into the matter, how far justified it is to boycott a Lok Adalat by lawyers. Then the article Lawyers and Lok Adalat manifested in the, because of that experience of mine. I'm glad that several senior lawyers of that station also, when it was published in AIR, had kindly come to me and expressed their opinion, most of them agreeing with it, some of them disagreeing with it also. But that is a different matter. The object of article is not to collect several people's favorable opinion. The object is to raise a debate. That has this debate. So I won't go much further into introducing each and every article. There is a saying, Bade Bhag Paiye Satsanga. Tulsidas has penned it in his Ramayana. It is a matter of highest fortune. Then one gets the company of learned people, people with erudition, scholarship, the legal luminaries, and several dignitaries from several other fields of social life. So I am in that company today. I am blessed with that. So how to reap maximum benefit from this situation? I think by talking less and listening more. May I thank you all. Thanks.
Thank you, sir. The book will be of great value to students, practicing lawyers, and judicial officers in the years to follow. I now request the esteemed guests on the dais and Mr. Vinay Ahuja, our publisher, to kindly release the book. Of course, Dr. Singhvi is connected online. He may also release the book. Thank you so much. Thank you, sir. Thank you, sir. We are privileged to have with us Justice Ashutosh Kumar. Before his elevation as a judge, Justice Ashutosh Kumar was one of the most popular senior advocates among the members of the High Court Bar. Always warm and congenial, he had an extensive practice on the criminal side and represented many convicts on death row. As a judge, Justice Ashutosh Kumar's cool temperament and pragmatic application of the laws is well known. As the executive chairman of the Bihar Legal Services Authority, Justice Ashutosh Kumar has taken many initiatives to bridge the gap to enhance access to justice. Under his leadership, the Legal Services Authority has organized mediation training program for lawyers and judicial officers and legal aid awareness camps in different parts of the state. I now request Justice Ashutosh Kumar to please address us on this occasion.
Very good morning to all of you, and thank you, Faucia, for such kind words. Just that one fact was incorrect. I was not a senior advocate. Nonetheless, we very fondly remember you and Shoaib for your grace, manners, and merits. God bless you. Honorable Justice Vishwanathan, Judge Supreme Court of India, Mr. D.K. Sharma, the author of the book which is going to be released, Mr. Faizan, a very popular Vice Chancellor of Chanakya Law University. I've had occasion to interact with him a number of times. Dr. Singhvi, a wonderful advocate. I have heard him speak in my court, otherwise on television. Brilliant orator and is an original thinker. My esteemed younger brothers on the bench. I call them younger brothers because all of them are younger to me. Former judges before whom I have appeared a number of times. We are very fortunate to have Judge Sri Vishwanathan here, who herself is a very consummate lawyer, had been. She doesn't practice now, for obvious reasons. Mr. Siddharth, the able son of a very able father, I would say abler son of a very able father. The publishers, the printers, judicial officers, I can see many of them, members of the bar, senior advocates, great advocates in making. I can identify them from distance. All are really good advocates in Patna High Court, and everybody present in this hall. It's a matter of great honor for me to be present here in this function, which is being presided where the chief guest is Justice Vishwanathan. I have read the entire book, all the articles in that book I have read, but there would be an associated disclosure along with this. I would not have read it now. I would have found out some time to read it, but for the fact that this book was being launched by a person as eminent as Justice Vishwanathan. There had to be something which would attract the attention of a reader. Justice Vishwanathan, I'll be talking about him for a purpose. I mean, I know great people do not like to be eulogized because they know what they are. They know their worth. But then I'll, if Justice Vishwanathan bears me out, sometimes in 1991, when former Prime Minister Rajiv Gandhi was killed by LTTE, a commission of inquiry was constituted of Honorable Justice M.C. Jain, where different parties were making their presentation. Justice Vishwanathan, as a lawyer, was appearing for AIA DMK, and when M. Karunanidhi, DMK, the adversary party, when he started talking in Tamil, then the commission asked Mr. Vishwanathan to translate it for him. And he gave the official translation there and then of the version of Mr. Karunanidhi, though he was the president of the adversary party and he was appearing for a different body, different political party, diametrically opposed to each other. But why do I remember this anecdote from 1991 now, at this occasion? As a token of a proof of that I have read Mr. Sharma's book, there is a chapter there which talks about training of judicial officers. He has said that there has to be a need for a pool of trainers who would train the judges not only in law, not only over key areas of judging, but also for developing their intellect, their building of their integrity and character. It is in this context that I remember that when Justice Vishwanathan, as an advocate, that time, when he made a translation, no questions were asked, no doubts were raised. This epitomizes the character which he had built up as a lawyer, the integrity, the honesty of purpose. He was representing a different party. The other aspect of this is with respect to a case which traveled from Patna. Here there was a constable who got failed in the examination because he had not written his correct date of birth. Sir would not remember the case, but I remember because I had an occasion to see it. He had mentioned the wrong date of birth that was very trivial compared to the documents which he had furnished. And his writ petition was dismissed by one of the judges of Patna High Court on the ground that the relief was not properly stated in the petition. Relief, he had not asked for his consideration of his candidature for being appointed. There was no mandamus sought. It was a loosely drafted, not happily drafted writ petition, and it was dismissed on that count. The matter traveled to Supreme Court, and Justice Vishwanathan said that no, a writ judge can mold the relief. For justice, justice cannot be altered on the, justice cannot be forsaken on the altar of technicalities. So this is pragmatism. So I have said about character building, pragmatism. The difficulty is that where do you find people like them to be trainers? Now that is the very serious area where we need to delve into. Now coming back to the book, Mr. Sharma, you have presented a huge canvas, a big marquee, so to say, covering topics ranging from expectations of the society from the judiciary, the speed versus quality in disposal of cases, mental health, environment, permanent lok adalats, legal aid, human rights, laws relating to women, and even the conundrum of Patna Municipal Corporation laws retaining the provision for licensing prostitution, notwithstanding the central law declaring prostitution to be illegal. Mr. Sharma, our former judge, he was very kind to visit Bihar Judicial Academy to train the officers. I think he is one of those trainers whom we need desperately for training our judicial officers, public prosecutors, and generally administrators. This book is a powerfully argued work of tremendous scope, written in simple style, and the adjective which I might give is that all the articles are marvelously sane in its approach, providing a cornucopia of ideas, full of ideas. And he talks about the necessity of writing such articles for giving impetus to thinking. As he rightly said, he exists because he thinks, and he thinks because he exists. He was absolutely right. Nothing could be more apt for this occasion. But there is an Austrian professor by the name of Sir Ludwig Wittgenstein. He has a very interesting thing to say about writing skills. He says he is a master of philosophy. He wrote about law. He wrote about logic. And he says in his famous book, Tractatus Logico Philosophicus, that what can be said at all can be said very clearly. And what cannot be said very clearly, one must be silent. Testing the book from this angle, I find that Mr. Sharma has not been hesitant even to speak on things where others would dare not. Many a times he has suggested in his book about how to go about administering justice. The other thing which came to my mind when I was thinking of speaking at the occasion about the title of the book, Flowers and Petals and Fragrance in the Flowers of Justice, a very interesting appellation, very interesting name. But why? He has himself very candidly stated that this is just kind of distillating his experience as a judicial officer. And therefore, it is more of, learning by experience and logic, the logic of life, the logic of law, than mere letters of law. So I think the purpose is to provide an insight, a thought by people at large, not only litigants, not only lawyers, not only judges, but everybody, what is the position of law and what are the silent spaces where something could be thought of, could be developed. Particularly the essay on the district judiciary and the constitutional law, I must say it was very thoughtful. At one place he says that why can an article, a laden essay, be not the basis for Supreme Court taking up the action? If the Supreme Court can take a epistolary, message to the Supreme Court, and the PIL could be heard on such issues, why not essays by judicial officers? He's absolutely right. Well said. But then the purpose, you see, the purpose is something different. Not only to have this idea, taken at the apex level and decided. The purpose is very, very different. He spells out what he thought, what he saw. Now, very recently, I was reading a novel. I mean, this would be a bit digression, but then when you have talked about the necessity of these articles being read by legislature, by judges, by people who are administering justice, I remember one novel. It is by Aldous Huxley. The name of the book is equally interesting. It says Point, Counterpoint. Now, in this book, the lead character, Mr. Sidney, he is a professor and he is researching on Indian government during Mauryan times. A very, I mean, for this kind of plot, you don't find such plots in English novels. So he was frequently visiting London from his hometown Essex. His wife grew very suspicious that why is he traveling to London every now and then? She doubted the intentions, but the husband would try and explain that, well, this was one of the novel experiments in ancient India. We don't regard India as the cradle of civilization, but there was a self-government, local self-government during Mauryan times, and there was economic growth and all that. He tried to explain it in detail. But still the wife would not agree. She thought that perhaps he had found a mistress in London and he wants to spend time. What is interesting in this, and why do I narrate this? He always tried to explain in detail why he is visiting London every time. The wife could sense it. The thing which has amused me in that novel, and the explanation given by the author Huxley says that without an evidence of any sort, the wife came to a right conclusion. And that conclusion was because he was insistingly talking about Mauryan administration over the dining table, and at length. What was the necessity? She thought that it was some kind of a squirting of ink by a hunted sepia in order to cover the movement, in order to camouflage the movement. So this, the husband had tried to hide himself behind the ink cloud of a story involving citizens, involving ancient India. Nothing of this kind with Mr. Sharma. He doesn't insist for anything. It's all fleeting articles, in-depth analysis, and rightly said, his articles can be the basis for the Supreme Court to take up certain issues with respect to administration of justice. The specific article that he has suggested that there should be a specific article in the Constitution dealing with corruption in polity, corruption in general. Well, it is, to my mind, it is one of the most elastic terms in English language, corruption. What constitutes corruption, we would not be able to define. It takes protean forms. In a pursuit like sports, match fixing, doping, so and so, all this would form part of corruption. These are all incidences of corruption. And somebody has rightly said, I think Supreme Court, I don't know which honorable judge has said this, but it says, well, corruption does not have wheels, it has wings. It can fly, it can overpower anybody. But then a specific article for Constitution, well, the makers of law would think about it. But the concern, Mr. Sharma, is definitely very genuine. We have to get rid of corruption. Lastly, I would say that the clarity and the conceptual innovative ideas in your essays only reflect your deep concern for upliftment of judiciary and faith in certain forms of non-utopian progress all around. The discussions in your essays reflect your understanding of law and general wisdom connected with such legally trained mind. It's always very refreshing to read such articles, to have a different perspective. Well, let me end now. Everybody is eagerly awaiting Justice Vishwanathan to speak. With his pearly wisdom, he shall be able to guide us in our pursuits. Thank you so much.
Thank you, sir, for addressing us. Our next distinguished guest is Professor Faizan Mustafa, the Vice Chancellor of Chanakya National Law University, Patna. Before CNLU, Professor Faizan Mustafa was the VC at Nalsar, Hyderabad, and is also a founding VC of NLU, Odisha. An erudite speaker, Professor Mustafa does not only teach law to law students, but is also someone who teaches law to an ordinary Indian. His interviews and legal awareness web series simplifies complex legal issues of contemporary relevance for a common man. The uniqueness of the style of Professor Faizan Mustafa and his tremendous outreach have added a new dimension to the phrase access to justice. May I now request Professor Faizan Mustafa Saab to please address the gathering.
Good morning, namaskar, adab, Honorable Justice K.V. Vishwanathan, Mrs. Jayashree Vishwanathan, Honorable Justice Ashutosh Kumar, judges sitting and retired in the audience, the learned author Dinesh Kumarji and Siddharth and Fauzia, ladies and gentlemen. The title is really interesting of this book, and I really feel privileged that the organizer found it proper to give me floor for a few minutes. कांटों से गुजर जाता हूं दामन को बचाकर, कांटों से गुजर जाता हूं दामन को बचाकर, फूलों की सियासत से मैं बेगाना नहीं हूं, फूलों की सियासत से मैं बेगाना नहीं हूं. The greatest living law professor and the only legal philosopher the country has produced is Professor Upendra Bakshi. Now, yesterday, Professor Bakshi, in response to a question from Justice Gautam Patel, former judge of Bombay High Court, as to the three qualities which citizens would like to see in a judge, spontaneously said, spine, spine, spine. Justice Abhay Asoka was also present on the dais. Spine is needed not just for writing judgments, but also writing books, because you invite a lot of criticism. Justice Ashutosh referred to that whole question of corruption. I personally simply don't agree that this should come in the Constitution. The other laws are good enough. Constitution should basically tell us on what subjects laws can be made. Of petals and fragrance in the flower of justice, a book which a retired district and sessions judge has written and Mohan Law House has published. When Mr. Sharma came to me, we had a long discussion about number of poems he has written, and many collections of his poems have also been published. So, book is very important in the religious tradition. If you go to Abrahamic religion, you have just one book. In India, we have plurality of books, and that's why at times I feel completely lost. Why this so much of emphasis, quote unquote, on oneness? One nation, one law, one Aadhaar, and now one subscription. Because Indian tradition is all about number of books. And Mr. Dinesh, following Indian tradition, has written many books. So you have many, many books from him. Now, as you look at this interesting title itself, I felt like recalling कि हमने कांटों को भी नरमी से छुआ है अक्सर, हमने कांटों को भी नरमी से छुआ है अक्सर, लोग बेदर्द हैं फूलों को मसल देते हैं. लोग बेदर्द हैं, फूलों को मसल देते हैं. I don't have the advantage of speaking on so many chapters of this book as His Lordship Justice Ashutosh has been able to do. But I feel in the limited time which I have, let me just concentrate on the very first chapter. And the title of the chapter is the title of the book. Now here the learned author, believing Justice Holmes that life of law is not logic but experience, is talking of expectations from judges, and that's why I'm connecting it with Professor Bakshi's yesterday's statement of spine, spine, spine. The author talks of quality of judgments and tries to do the impossible, because in India we have not talked of performance of judges like United States. And he identifies 4 major qualities: judiciousness, fairness, equality, and compassion. And then he defines judiciousness as endeavor to impart wisdom and soundness in the judgments. And following the principle that justice hurried is justice buried, he very clearly says that undue haste in judgment writing or judgment delivering is antithetical to judiciousness. Under fairness, he has included honesty and integrity, and then he says that honesty is not just about the monetary honesty, it includes several other honesties, including the intellectual honesty. Then he talks of equality and compassion. Many of us as citizens don't have compassion, some judges don't show compassion. At times, the compassion is reserved only for the rich, and I'm saying it because Dinesh ji is talking of bails. Recently, you saw how a rich boy got a bail and was asked to just write a 300-word essay after committing that serious accident. Now, after reading this book, I am convinced, in fact, there is a chapter about district judiciary and constitution, that probably the time has come that we start thinking of giving writ jurisdiction also to district judges. If district judges are of the caliber of Dinesh Kumar Sharma ji, no harm in reducing the burden of the constitutional courts. Since Justice Ashutosh also referred to the quality of judges, and Professor Bakshi said so, and then he talked about the 4 qualities, I think I need to say just for a minute that judicial independence and judicial accountability are closely connected. Judicial accountability promotes at least 3 distinctive values: the rule of law, public confidence in the judiciary, and the institutional responsibility. As a matter of fact, many judges and many of us don't realize that judicial independence and judicial accountability is not an absolute ideal. Both are purposive devices designed to serve greater constitutional objectives. True independence of judiciary is indeed the basic structure of our constitution, but then judges must appreciate that it is not an end in itself. In fact, it is rather an instrumental value defined by the purpose it serves. Even under the Roman law, a judge could be held liable for damages if he failed to appear in the court at the agreed time, to adjourn for just cause, to hear both sides equitably, to give judgment in good faith without animosity or favor. For all these, there was an accountability of judges under the ancient Roman law. Similarly, in Sweden, judges were subjected to mild criminal sanctions for breach of duty till 1976. And in Denmark, since 1939, a special court of complaints has been created to hear complaints against judges. I am simply not suggesting that we follow either the Roman law or the Swedish law or the Danish law. This is not my argument. but we should try to assess the quality of judgments, as the learned author has referred in chapter 1. And this is a question which, unfortunately, in India has not received much juristic attention. And that is why the very first chapter, attracted my interest, and I read the whole book like this. Now, as you go to United States, many states in US do follow what is called a merit plan, under which judicial performance of state supreme courts and other courts is evaluated. As you know that each state has a Supreme Court in the United States. So the performance of judges is evaluated through a vote or as a device of self-improvement. Some states have judicial performance review commissions or councils such as Arizona, California, and Utah. Now, these commissions consist of not only judges and lawyers, but also lay persons. New York and Alaska have systems of evaluation of judicial performance by the trained court observers who make unscheduled visits to courts. Judges are evaluated on their knowledge of law, integrity, sentencing, and impartiality. New Jersey used judicial performance evaluation simply as a mechanism to felicitate improvement of individual judges. Thus, I believe that there is a need in the country to have some kind of deliberations and discussions on the whole question of evaluating judicial performance. Of course, the memorandum of procedure for the appointment of judges in High Court and Supreme Court does talk of integrity. If you go to the state of Alaska in the United States, integrity is evaluated on indicators such as equal treatment of all parties, sense of basic fairness and justice, conduct has to be free of impropriety, and finally, ability to deliver decisions without fear or criticism. And therefore, that is fine thing. And that is why I feel that if New York and Alaska and California and other states are doing this, and a retired judge of our judiciary is talking of judicial performance, I think this is something which is very, very important. And I congratulate the author on the publication of book and for giving such an interesting title. लोग कहते हैं लोग कांटों से बच के चलते हैं, मैंने फूलों से जख्म खाए हैं. Thank you very much.
Thank you, sir, for your address. We are privileged to have with us Dr. Abhishek Manu Singhvi, who has very kindly agreed to address us virtually. Dr. Singhvi is one of the most prominent and well-known senior counsels in the country. He continues to be the youngest ever designated senior advocate, being designated at the young age of 34. The youngest appointed ASG at the age of 37. Dr. Singhvi studied economics at the prestigious St. Stephen's College, law at Trinity, Cambridge, and PhD also from Trinity, Cambridge, under the supervision of legendary Professor H.W.R. Wade, later known as Sir William Wade. With a talent for breaking down the most complicated legal problems into points, Dr. Singhvi's oratory and knowledge of law is legendary. An ultimate multitasker, Dr. Singhvi's multifaceted and versatile personality straddles public life, media, law, and academia. A 4-time parliamentarian, Dr. Singhvi has also very kindly written an introduction to the book. May I now request Dr. Singhvi to please address us on the occasion.
Vishwanathan, who defected from amongst us, leaving a lot of sweet and good memories and a large pool of admirers in the bar. And unfortunately, we can't apply the 10th schedule to him. Justice Ashutosh Kumar, who carries the fragrance of Delhi with him. And I remember, not entirely in jest, I suggested to him before he left that the bar was seriously considering moving a mandamus petition to prohibit him from leaving the boundaries of Delhi. That's an unusual compliment to Delhi, which is rather jealous about its persons. And he acquired that love and affection in a very short while. Above all, the author, Mr. Dinesh Sharma, my good friend Mr. Siddharth Sharma, Mr. Vinay Ahuja, the publisher, sitting and former judges of the High Court and of the District Judiciary, distinguished members of the legal fraternity, ladies and gentlemen. Speaking before Justice Vishwanathan allows me the preemptive opportunity of clarifying my virtual presence and physical absence before he makes a quip or two about it, which he may well be itching to do. I was actually to do this virtually from Odisha, and the uncertainty of that Odisha program on Saturday was settled so late that other exigencies cropped up in Delhi, by then preventing physical travel to Patna. But after the Supreme Court push on technology and VC, my virtual presence should be judicially validated by the eminent judges on this book release bench at Patna. Friends, I have said much of what I wanted to say in this fancy word for introduction, prolegomena, to this wonderful book, including on individual chapters. And I don't want to repeat it. But just consider, if I was to use the words poet, music lover, Muhammad Rafi aficionado, harmonium player, quantum mechanics student, author and movie buff. And after all these words, if I was to add the word district judge to all the earlier phrases, you would definitely justifiably think that I am unleashing a big oxymoron upon all of you. But incredibly, Dinesh Sharma, the author, is all of these and more. He is truly a weird subspecies of the professional tribe of law persons, which he also proudly belongs. If law is his vocation, then poetry must be his anchor. Music must be his balance, and quantum mechanics must be his tool to sharpen the power of his judgments. I have always believed that our legal system runs on that wise and hard-working lawyer in that remote district court of India who seeks more sense and less sensation, just as it runs on the back of that anonymous district judge who does back-breaking labor with his nose to the ground in another backwater of India. And surely Mr. Dinesh Sharma must have travelled through those backwaters, neither seeking recognition nor getting his due. Just indeed as it runs on the shoulders of several unknown High Court judges who discharge their duties diligently, without expectation or even justifiable reward. It is true that this tribe is diminishing at all levels, and probably diminishing at an alarming rate. But they remain the backbone of our system, and they can rightly be called our unsung heroes. A few amongst them, and Mr. Dinesh Sharma stands right in the front rank of those few, have transcended all those adversities of their ecosystem, not only to discharge their judicial duties outstandingly, but to keep alive such diverse Renaissance man talents alive. And it's not easy, friends, without allowing their extinction amongst the dead sand of mediocrity and habit. Dead, dreary sand of mediocrity and habit. The ecosystem I talked about can be benumbing and can deaden the most lofty instincts. And it's quite miraculous that a man like Dinesh Sharma has kept those instincts alive. As of 2024, roughly 28%, 7,000 plus posts, stand vacant in the district judiciary and below. While our judge per population, per million population, has agonizingly crawled up from 12 to 21, between 2002 and 2021. The facilities for the so-called first point of contact for a citizen in search of justice, and being this the crucial component of rule of law, as former Chief Justice Chandrachud put it recently, those facilities have certainly not kept pace. As recently as 2023, a law ministry report finds that 37% of judicial officers complain of lack of adequate operating space, lack of sufficient degree of computerization, digitization, insufficiency of adequate support staff, and not only in numbers but in training. The approximate average disposal time, be it of criminal or civil cases, at the district level shows huge diversity between different Indian states. Delhi and Kerala are somewhere taking half the time, Bihar and UP are taking double the time, and Maharashtra falls somewhere in between. इस किताब के प्रारंभिक कथन में मैंने लिखा था कि कैसा विचित्र विधान है, कैसा विचित्र विधि का विधान है कि मैं एक ऐसे व्यक्ति की किताब के लोकार्पण पर बोल रहा हूं जिससे मैं कभी मिला नहीं, जिसकी कविता संग्रह की प्रस्तावना 20 वर्ष पहले मेरे पिताजी ने लिखी, और उसी समय श्री दिनेश शर्मा के दिमाग में इस आज की किताब संग्रह का बीज डाल दिया। इससे आगे ज्यादा अजीबोगरीब बात यह है कि मैं लेखक के पुत्र को काफी अरसे से जानता, लेकिन उनके पिताजी की इतनी सारी बहुमुखी प्रतिभाओं के बारे में अनभिज्ञ था। आज का दिन पुत्र को अपने पिता पर गर्व करने का दिन तो निश्चित रूप से है, लेकिन साथ साथ पिता को भी अपने पुत्र की अनेक उपलब्धियों पर अत्यंत संतुष्ट होने का भी दिन है। मैं निजी अनुभव से पूरे विश्वास के साथ कह सकता हूं कि सिद्धार्थ ने बहुत अल्प आयु में कानून के क्षेत्र में कई मील पत्थर पार किए हैं। टाटा ग्रुप के कठिन समय में जब कई वर्षों तक सिद्धार्थ ने मेरे साथ काम किया, और सबसे ज्यादा मेरे साथ लगभग 2 वर्ष तक काम किया, मैंने पाया कि उसकी बुद्धि तीव्र है, सोच दूरगामी है और सुझाव बेबाक और स्पष्ट हैं। जहां तक सिद्धार्थ का सवाल है, मेरा मानना है कि अभी तक सब कुछ ट्रेलर है, पिक्चर अभी बाकी है। और अपने स्तर पर बताऊं मैं आपको कि सिद्धार्थ अपने पिताजी के हारमोनियम के साथ तबले पर जुगलबंदी में शायद 21 उतरेंगे, 19 नहीं। अंत में कवि, लेखक, वैज्ञानिक, कानूनविद, पूर्व न्यायाधीश और सर्वोपरि मोहम्मद रफी के अटूट प्रशंसक, फैन, और जो उस अभूतपूर्व गायक की स्मृति में हर वर्ष 20 वर्ष से उनके मृत्यु दिवस पर एक बड़ा आयोजन करते हैं, उनको श्रद्धांजलि अर्पित करते हैं आज तक, उनको कश्मीर की कली फिल्म की रफी की कुछ पंक्तियां द्वारा बधाई देना चाहता हूं। रफी ने किसी और संदर्भ में कहा था, संदर्भ भिन्न है, तारीफ करूं क्या उसकी जिसने तुम्हें बनाया। और रफी के अलावा शायर ने कहा है, अन्य शायर ने, और जो मैं समझता हूं दिनेश जी के लिए पूर्णतः उपयुक्त है, जिनकी फितरत में हो अदब और तहजीब की खुशबू, जिनकी फितरत में हो अदब और तहजीब की खुशबू, वो खुद ही बन जाते हैं फूल, तारीफ की जरूरत कहां। बहुत बहुत धन्यवाद, और माफी चाहता हूं मैं वहां हूं नहीं इस बड़े महत्वपूर्ण दिवस पे।
Thank you, Dr. Singhvi, for addressing us. Our chief guest for today needs no introduction. As a leading senior counsel, his vast knowledge of law, elephantine memory, original thinking, strategizing, and the application of first principles made him one of the busiest lawyers in the country. For decades, while at the bar, Justice Vishwanathan was a pillar of support, encouragement, and inspiration for many members of the bar, and many young lawyers have had the privilege to be mentored by him. Since cricket happens to be Justice Vishwanathan's great love, in cricket terminology, he can be best described as an expert all-rounder in all branches of law. In a period little over than 16 months as a judge, Justice Vishwanathan is already known for his incisive and easy-to-understand pronouncements on a wide variety of subjects, his unwavering commitment to the rule of law, and his concern for the common man. A legal visionary, Justice Vishwanathan's latest judgments on legal aid to prisoners and advancing disability rights are shaping the judicial landscape of the country. It's my great privilege and honor to request Justice K.V. Vishwanathan to please deliver his keynote address.
Thank you, Fauzia, for that very, very generous introduction. Justice Ashutosh, distinguished Senior Judge of the High Court of Judicature at Patna, Dr. Faizan Mustafa, Professor Vice Chancellor, Chanakya Law University, distinguished Senior Lawyer, Member of Parliament, Dr. Abhishek Singhvi. I don't propose to make any quip because even now here in the auditorium, there are young lawyers looking at the door thinking that you would still surface like you do in court. Distinguished judges, present and former of the High Court of Judicature at Patna, Siddharth Sharma, the proud son, Vaishnavi, and members of the family of Sri Dinesh Sharma, the bridegroom of the evening, Dinesh Sharma ji, distinguished senior lawyers, ladies and gentlemen, a very good afternoon to you. I must say at the outset that I am extremely privileged and honored to be invited to be part of the book release function of a book authored by a very, very distinguished personality. I was also honored to be invited to write the foreword for the book, and unlike Dr. Singhvi, who did not want to read his introduction, you will permit me to read parts of the foreword, because as I read the book, at every turn of the leaf, my respect for the author, whom I had not seen till then, grew up in several notches. So I have penned the foreword after a study of every word and syllable of the book, and I hope you find the foreword to be penned from the bottom of my heart, because here is an author who, as Dr. Singhvi said, is multifaceted, who was also a very distinguished district judge, but is a very rare human being. You will find from the book that the values he espouses, the values of honesty, values of integrity, really show the measure of the man. Like you, sir, my father for very long, before he had a stint as a standing counsel in the Supreme Court, served as a prosecutor in the trial judiciary. So I can directly associate the amount of hard work that goes behind the scenes of the personalities who work at the field level in the judiciary. And as was said, they really don't care for the recognition. Their names may not be in the morning newspapers. You may not have their photographs like we have sometimes of some of us put on the television channels. It doesn't matter. That is not what matters at all. What matters is if at the end of the day you have discharged your work to your utmost satisfaction if you have delivered justice to the common man. But if in the midst of doing all this, if there is someone who has over a period of time been able to put his thoughts down to paper and then have them published, incidentally it is the author's 4th book, and that speaks volumes of his caliber. So we will slowly go through but at a reasonable pace, go through the foreword, because this is a book which each one of you must possess and each one of you must read over a period of time. It has several ideas which, if implemented, could go a long way in reforming our legal system. It has certain revolutionary ideas, as the Vice Chancellor mentioned, some of them capable of immediate implementation, some of them which require a deliberation, some of them perhaps may not be implementable in the form that he advocates, but as the author rightly says, the idea is not to assemble a consensus for the book, but is to liberate the minds of the individuals so that they are set thinking on this direction. So here is what I have written, and I want to place before you the same so that you fully absorb the treasure that is hidden in the pages behind this book. The trial judiciary constitutes the foundation of our judicial superstructure. It is extremely vital that men and women, not only of ability and integrity, preside over those courts, but it is essential that they also possess expertise in law, that there are such individuals who man those positions. And when I say man, it also includes women. In our country is common knowledge. However, when you come across a gem among those who partook of the judicial power of the state and functioned at the level of the trial judiciary, one has to sit up and take notice. Shri Dinesh Kumarji, who retired as a district and sessions judge in the Bihar Judicial Service, has, through this bouquet of articles offered in his book, demonstrated his immense caliber, extraordinary learning, capacity for original thinking, uncanny knack of identifying the real problem, and his ability to offer a plausible solution. The book that was released today is a product of considerable years of experience, blended with a strong commitment for institutional reform. The anthology of articles written during the first decade of this century has been compiled by the author's affectionate son, Siddharth, who himself is a lawyer of immense competence. We will later in this talk see 2 couplets from the divine Tamil poet Thiruvalluvar as to what the father's duty of a son is and son's duty to a father is. So Dr. Singhvi did mention, but I want to mention it through the words of Thiruvalluvar, but that will wait for a little time. Now see the subjects that are covered in this book. The book has articles from diverse branches of law like civil law, criminal procedure, environmental law, constitutional law, matrimonial law, and has also a chapter devoted to the vital local laws of Bihar. Apart from this, the author, driven by his passion for excellence and in his zeal for judicial reform, grapples with correct training methods for judicial officers. And why do we say correct? You will get it a little later. And also about the conduct of Lok Adalat, the legal aid clinics, the procedure for case management in courts, and the importance of resolving disputes through mediation. According to the author, the hallmark of a good judicial officer, and this is where, only if you practice that you can really preach it, it will come from within, is that She should be industrious, well-read, and should possess the capacity to think. The author not only possesses each of these qualities in abundance, but also, as the book displays, has a felicity of expression and an ability to deploy appropriate turn of phrases to arrest the reader's attention. The articles, though dated, they are all published through the early part of the century, are punctuated with several original ideas, which if implemented could give a fillip to our legal system. Emphasizing on the need of quality in justice dispensation, the author implores that the fragrance of quality must be allowed to permeate the petals of quantity in the flowers of justice. The parameters, according to the author, are judiciousness, fairness, equality, and compassion. This is a significant idea aired by the author as early as in 2007, since the debate today is about what is the proper method of assessing the performance of the trial judiciary. Recently, the Chief Justice who demitted office, Chief Justice Dhananjay Chandrachud, an eminent, erudite judge, made the distinction between quality and quantity when he said that when you are assessing the performance of the judges who preside over the CBI courts, quantity cannot be the basis. As you would be aware, CBI cases run into reams and reams of papers. It is not easy to dispose a CBI case overnight. So the assessment for a judge handling a particular type of case has to be based on the quality of disposal and not on the quantity, and that is already addressed as early as the turn of the century in the book. And now when we come to the training for judicial officers, the author emphasizes very intelligently, very ably, the distinction between training a raw judicial recruit and a judicial officer who is seasoned and who is attending the academy for continuing legal education. Now look at the difference. The qualitative difference in the parameters between training fresh entrants in judicial service and senior judicial officers are, for a fresh officer, he says, training program should be suitably conceived to generate abundant self-confidence in the minds of the entrant. Judicial decorum and discipline, maintenance and drawing up of judicial record, knowledge of court fee and suit valuation, and the art of writing judgments. No use having a same training schedule for the experienced judicial officer. For senior judicial officers, the author emphasizes that the training should be on optimizing judicial time, equipping them in subjects not covered in the curriculum in colleges, like forensic medicine, medical jurisprudence, DNA testing, science of fingerprints and handwriting, ballistics with special reference to their probative value and their constitutionality and admissibility during trial. What is the admissibility of the, narcotics what is that called, Selvi, as the state of Karnataka? The narco analysis. One must know what narco analysis is, is it an investigative tool permissible under the constitution, what does the judgments of the Supreme Court say? Those are the trainings which a senior judicial officer will need. As you progress into the book, there are extremely relevant and revolutionary ideas waiting to receive you. To alleviate any further dispute on whether a decree, look at the importance of this, whether a decree requires a registration or not. Sometimes when in a compromise, there is a conveyance of immovable property. In what circumstances does it require registration? There is a subsequent litigation which happens after the decree. The author has a very novel suggestion. The author suggests that judges should be required in the order itself to put down directions to the effect that the decree was not to operate to create title unless registered. In the very decree, if it is a compromise between where there is a conveyance, unlike in a compromise where there could be between parties having pre-existing title. According to the author, this will remove any further disputes. These are the creative ideas you need now because we are facing at a huge docket explosion. Dr. Singhvi mentioned very crucial statistics on the infrastructure vacancies. As of last week, the broad figures are that there are over 5 crore odd cases pending in the trial judiciary, about 60 lakh cases pending in the high courts, and about 82,000, which includes cases lying in the defect section in the Supreme Court. Now look at my favorite part of the book, which really, astonished me. I was not only pleasantly surprised reading it, but I'll tell you a small incident which happened after I wrote the foreword. Today we are talking of environmental law, today we are talking of climate change. There is a chapter in this book written in 2001 where the author advocates for an environment bench in the ICJ tribunal. And when I wrote the foreword and sent it to Siddharth, he said, actually the article was written in the late 70s at the Benares Hindu University. Now, talking of environment, pollution and climate change in the late 70s is nothing short of a visionary which we find in the author. And that chapter requires special commendation, and I implore you, all of you, to read them. The author obviously belongs to the tribe of judicial officers who took pride in their calling. He writes in the chapter heading, "The resolve for the new millennium," that as the first resolve, one must feel in the heart of our hearts, sublimely proud for belonging to and being a humble member of the great institution of judiciary. No talk of judicial ambition, no talk of getting here, getting there. He's already embedded the thought that ambition can be the besetting sin of an individual. Emphasizing on integrity and fearlessness as non-negotiable attributes for a judicial officer, the author states that the next resolve to which the members of the district judiciary must commit themselves is to rededicate to the cause of the society by rendering timely justice, justice that is humanized and yet untainted by fear or favor or any influence that are manifestly festering several other departments of our socio-political life. Then comes the aspect which the author touched upon about how constitutional law is not just the domain of the judges of the constitutional courts, and how every constitutional right has its origin or has embedded in it a civil right. And if Section 9 of the Code of Civil Procedure can say that every suit is maintainable unless expressly or impliedly barred, there is no reason why certain rights which qualify as fundamental rights could also not be enforced through the medium of the civil courts and the criminal courts. The author argues that all fundamental rights are also civil rights unless expressly or impliedly barred. The author states that the judiciary can always incorporate as part of their foundational reasoning provisions from the Constitution and their interpretation. A very salutary thought, because the first interface is with the trial court. When a prisoner is arrested and produced and he is remanded, there is Article 21 and 22 in operation. The author elucidates that fair criticism was part of the fundamental right of freedom of speech and expression, and alludes to cases where he applied that principle while considering the validity of exercise of power under section 144 of the old CRPC. Now we are referring to the 1973 CRPC as the old CRPC. Till recently we were referring to the 1908 one as the old CRPC. The deep knowledge possessed by the author in constitutional law manifests itself when a hitherto largely unnoticed article, Article 32, Sub-Article 3 of the Constitution, is tapped by the author and a case is made out to confer writ jurisdiction on the district judiciary. Already Dr. Faizan Mustafa touched upon the aspect, and Justice Ashutosh also dealt with the clamor of the author to recognize the fight against corruption as part of the constitutional right. I mean, that is a cry in anguish because corruption has been cancerous. It certainly requires heightened attention. It requires immediate, address, redressal. But how to do it, I think it's an idea which is floated. One other interesting aspect is whether Section 11 of the Pension Act of 1872 could be reconciled with Section 125. And the author says, CRPC, and the author says that for arrear of maintenance, on a careful reading, even pension could be attached. The analysis stands out for its originality and repays study. Legal aid and the awareness for legal aid is another area which the author has highlighted. He has discussed on case management, he has discussed on Lok Adalat. This book should adorn the shelf of every judicial academy and every law library. It will be useful for lawyers, judges, law students, lawmakers, and to all those who have uppermost in their mind the need to reform the legal system for producing a better judiciary. I congratulate the author for periodically penning his thoughts. Through the words of the author, it is easy to infer that he had led a life as a man of letters and during his stint as a judicial officer gone about his work with impeccable integrity and rectitude. Now here is where I want to discuss Thiruvalluvar and wind up. My good wishes to Siddharth Sharma, his devoted son, for taking up this project of compiling the work and publishing them for the benefit of the legal fraternity. I congratulate Mr. Vinay Ahuja, the publisher. The father-son duo of Sri Dinesh Sharma and Sri Siddharth Sharma remind me of two couplets of the famous Tamil saint poet Thiruvalluvar in his epic Tirukural, where he talks of a father's duty to his son and vice versa. पुत्र के प्रति पिता का कर्तव्य यही है कि वह उसे विद्वानों की सभा में आगे की पंक्ति में बैठने योग्य बनाएं. What is the duty of the father to his son? It is to make him worthy to sit in the front rank in the assembly. What is the duty of a son to his father? पिता के प्रति पुत्र का यही कर्तव्य है, वह लोगों से कहलवाएं कि ऐसे उत्तम संतान को प्राप्त करने के लिए इसकी पिता ने, संतान would include daughter also, because this is all said when times were, different. Under the General Clauses Act, masculine includes feminine. I will read that again. पिता के प्रति पुत्र का यही कर्तव्य है, वह लोगों के कहलवाएं कि ऐसे उत्तम संतान को प्राप्त करने के लिए इसकी पिता ने कितना बड़ा तप किया होगा. What is the duty of the son to his father? It is to make the world ask, for what penance of his hath he been blessed with such a child? I congratulate Sri Dinesh Sharma ji for publishing this book. I wish the author many more books to the pen. I congratulate the family, and thank you for spending your time here this afternoon. Thank you very much.
Thank you, sir, for your insightful thoughts, underscoring the relevance of several views of the author in the book, and for the very apt and moving words of the Tamil saint Thiruvalluvar. I now request Prashant, a practicing lawyer in the Karnataka High Court, our very dear friend and Siddharth's batchmate from NUJS, to please deliver the vote of thanks.
Thank you, Fausia. Distinguished guests on and off the dais, friends, ladies and gentlemen. Usually, a vote of thanks is a customary exercise which is very mundane in nature, often dry, hollow, mundane in nature. But with all your permission, may I just steal a brief moment to express my very deep, personalized sense of satisfaction and fulfillment this morning. The reason why I am here, the authority and jurisdiction in a legalese phrase that I hold here is that my dear friend Siddharth extended, like he did to Fausia, the privilege of treating me as a part of his family. So 2 weeks back when he said that this function was upcoming and I said I would definitely come because your father is like my father, he said, then why don't you propose the vote of thanks? And I said I'd be delighted to. And that's the sense of authority and jurisdiction with which I am addressing you, though of course I don't practice here, I don't belong here, I belong to Kerala, I practice in Bangalore. I think as we draw this function to its conclusion, the most overarching sentiments of the day is one of immense appreciation for the life that the author has lived and the contributions that he has done to the profession as a very big functionary in the legal field, which is manifested through his work. It goes without saying that be it law or be it life in law is often characterized by plurality and not by what Dr. Faisal Mustafa was concerned about. It is often a matter of plurality, it is a matter of diversity that we see when we look at both law and life in law. I remember Siddharth's and my great guru, Dr. Madhav Menon, taking on the first day the LLM batch of the university to the library. He showed them around and he said, this is your syllabus. That was an intimidating moment possibly for them, but that really told them that life is all about a basket which is both of humility and of confidence together, which are not contradictory with each other. I remember Dr. Menon coming to our class, the undergraduate class, asking, the first class was in economics. So he went from one student to the other, asked all the 100 students, what is your definition of economics? So we all gave some definition of the other, I gave mine. End of it, he said, the definition of economics is what all of you have said and much more. And therefore, he lifted the study material of NUJS and said, and therefore, our book on economics does not start with the definition. Because the moment it starts with the definition, it forecloses, and that's a disaster. I think that diversity of law, that kind of diversity and plurality of law, the traffic outside is governed by law, how this building has come up is governed by law, electricity that makes us function is governed by law, water and food that we drink are governed by sets of law. Any facet of human life and civilization is governed by some law or the other. And that kind of diversity of law also enables us to be ourselves and function in our own style, be it as lawyers or be it as judges. The way how a Fali Nariman argued is not the way how a Soli Swarabji argued, and definitely not how a K.K. Venugopal argues, definitely not how a Harish Salve argues, or Dr. Abhishek Manu Singhvi argues. The way how one judge decides is not how another judge on the same bench decides. The way how trial court decides is not how the High Court decides, that's not how the Supreme Court decides, and Supreme Court is final only because there's no court above it. And if that's the diversity and plurality that we are talking about, be it in the subject of law, which the common man thinks should be cast in stone, or be it in the life in law, then we ask this beautiful question as to how our author has lived his life as a high functionary in the field of law? And the answer is brilliant. These essays were not written after his retirement. These essays were written at the time when he was attending to the daily chores and deliverables as a legal officer, and that's phenomenal. Most of us as lawyers or judges, I would assume, see that our days and nights are getting filled up by deliverables. And I'm sure as judges, the deliverables never end. In between, to be able to probe into the philosophy of law, to find what was the mischief that the law tried to achieve, tried to attend to, and what is the mischief that follows the law, and what's the remedy for it, is a phenomenal mental exercise. And if a judge during his tenure, very recently somebody sent me a funny WhatsApp message that said that both sides in a court know the facts. It is a judge who is on trial. And I said yes, because today, and I'm sure Justice Vishwanathan would agree, that today, even on a small screen, it is the judge who is judged the most. And if our author, under such very strenuous circumstances, even a surgeon, even the best surgeon practices under a certain privacy, but under the public glare when he functioned, if he managed to work in a zero error zone insofar as his jurisprudence is concerned, then of course that is the highlight that we are carrying back today. Therefore, ladies and gentlemen, your participation today has in fact added to the grace, to the energy, to the radiance of that outstanding nature that our author today stands for. And that is the one for which I wanted to thank everybody. Siddhartha has given me a long list. I will, of course, thank our main dignitaries and then read out the list of various people who made this morning a possibility. First, of course, let me thank our chief guest, Sri Justice K.V. Vishwanathan, for traveling all across, along with his wife, Mrs. Jayashree Vishwanathan, for taking the pains to come all over and grace the occasion. So as I said, I feel like a part of this family, and therefore on a very personalized note, ma'am and sir, let me thank you from the depth of my heart. Let me also thank Justice Ashutosh Kumar, who I'm meeting for the first time and who spoke so eloquently about the legal profession and his vision. I thank you, sir, from the depth of our hearts. We, of course, thank very profusely Dr. Abhishek Manu Singhvi, advocate, member of the Rajya Sabha, and who, though couldn't personally make it, gifted us with a brilliant speech, as he is always associated with. And let me not get into the details, but it was in 2002 or 3 when I and Siddharth were staying together in a paying guest accommodation in Delhi, that Siddharth, along with his father, had gone and met Dr. Abhishek Manu Singhvi when I was interning with Mr. Venugopal. And I remember that evening when he came back and spoke volumes about Dr. L.M. Singhvi. And Sir, Dr. Abhishek Manu Singhvi, we are very thankful to you for your presence, for your virtual presence here and gracing us with your speech. I also profusely thank Professor Dr. Faisal Mustafa, Vice Chancellor of CNLU, Patna, who is an institution maker, and that's a different role altogether. As an institution maker in law, he has excelled. He brought up the Nalsar in Hyderabad, later experiments in Orissa, and now doing very well here. And thank you so much, sir, for your presence and participation today. I will just read out the list because there's a long list of people who very dearly made it possible. All the honorable judges sitting and former of the Patna High Court, I can see Justice Bhajantri from my parent High Court here. All the honorable judges from the district judiciary, the members of the bar, the members of the registry and protocol office of Patna High Court, Mr. Vinay Ahuja, the proprietor of Mohan Law House, his colleagues, Mr. Abhishek, Mr. Jitendra, then Mr. Adrian Terran and Mr. Mukund Moge for helping with the cover design, members of the press, the entire team of Taj, General Manager Mr. Siddharth Jain, his colleagues Vikas, Suraj, Rohini, Rahul, Taufoj, the chef Vishwajit and team, Pavan and team for the stage and the audio visual setup, the list of our individual friends, Fausia of course, Rajesh Ranjan, Mr. Amit Mishra, Mitakshara, Rishi Prakash, Rakesh Jha, Asim Samuel, Sarida Kamath, Ganesh Kamath, Hemant Kumar, Vaishnavi Sharma. Let me just thank everybody in one word and conclude by saying that the energy, the sheer energy that we take away from this function today should hold us in good stead in the days to come. Greatness, in fact, is a very elusive concept, be it when you go and brief a senior counsel or be it when you see a judge function. The input getting into a certain output is a very difficult process to understand unless you lift the external casing and gaze deep into the individual. Today with this book, our author has given us a demonstration of the individuality which has resulted in the greatness that he stands for. And therefore, I believe the value of the book and the value of the function is immense. In fact, the cost of the book is what it took to bring out the book. The price of the book is the money with which you buy the book, but the value of the book is immeasurable. And the value of the book today has been augmented, has been strengthened, and has been absolutely radiated by all your presence and participation. Once again, thank you all from the depth of our heart.
Thank you, Prashant. I request all the guests here to please join us for lunch. I again thank Dr. Singhvi for connecting virtually. Thank you very much. Virtual lunch.
This will not be counted as a virtual lunch, sir. This will be a udhar.